call this meeting to order. And with that, we'll ask the photographers and cameras to leave the room. Thank you. And welcome everyone to meeting number 31 of the Standing Committee on Access to Information, Privacy and Ethics, pursuant to Standing Order 1083 and the motion adopted by the committee on Tuesday, July 26th, 2022. The committee is meeting to study device investigation tools used by the Royal Canadian Mounted Police. Today's meeting is taking place in a hybrid format pursuant to the House Order of Thursday, June 23rd, 2022. For the first hour of this meeting, we are pleased to have the Honourable Marco Mendicino, Privy Councillor, Member of Parliament, Minister of Public Safety. So with that, I will invite the Minister, if he is ready, to proceed with opening remarks. Actually, before I'm going to allow, I can't see his picture fully on my screen, but it appears to me, I don't know, Minister, do you have your proper headset with you?
I'm in the Minister Regional Office in Quebec here, and so I'm told that these are devices which have been approved by PCO.
Okay.
If there's any trouble, please let me know.
I'll just make a quick survey of the room and the interpreters and confirm that we've got good audio. Are we okay with the Minister's audio? Okay, I'm not seeing any objection, but it's not clear. I didn't see any reaction from interpretation. I see some nodding. Okay, all right. Then with that, thank you, Minister, and go ahead for...
point of order.
Go ahead. All right. Sorry, there seems to be a point of order before we begin. Ms. Khalid, you have a point of order?
Yes, Chair. I just wanted to review something from the last meeting. Now, near the end of the meeting, the committee decided to continue for another round of questions. And at the request of an opposition member, the Chair, yourself, Chair, you changed the timing for that additional round to be 5 minutes for each questioner as opposed to what was outlined in the routine motions. I would like to point you to one of the routine motions that was passed unanimously by this committee, December 13th, 2021. On motion of member Lisa Hefner, it was agreed that witnesses be given 5 minutes for their opening statement, that whenever possible, witnesses provide the committee with their opening statement 72 hours in advance, and that at the discretion of the chair, during the questioning of witnesses, there be allocated 6 minutes for the first questioner for each party as follows: Conservative, Liberal, Bloc, New Democrat. For the second and subsequent rounds, the order and time for questioning be as follows: Conservative, 5 minutes; Liberal, 5 minutes;
if I
Bloc,
may,
2.5 minutes.
If I may, Ms. Khalid,
yeah.
I am fully aware of the motion and its content, and if you will recall in the meeting, when there was a request from a member just to go with, for one member to have a 5-minute round, when we had exhausted 3 full rounds, there appeared to me to be unanimous consent to proceed in the way that I did. I was merely allowing members with the time that we had left after a lengthy meeting to go ahead and give each party 5 more minutes. But if I may infer from this intervention that you will not agree subsequently to any other deviation from that motion, then that is noted. I don't think that we're going to have time for that to be relevant anyway with any of our further meetings, given how tight they are. So if that's sufficient, may I proceed with our witness?
This is a point
Yes,
of order.
thank you.
Okay,
Point of order, Mr. Chair?
sorry, we have another point of order. Okay.
Yeah, referencing the standing orders and the
Green,
routine
quickly.
procedures. Has the minister provided this committee with the opening remarks in advance of the committee?
Yeah, I did not receive any. I'll ask the clerk if any were received. Oh, okay. The clerk has in fact received remarks, but it does appear that they were not distributed to members. I did not receive them, so we will try and get those out as quickly as possible. So thank you, Mr. Green. And with that, all right, we're burning up the time we have with the minister, but go ahead.
We do not see the minister on the screen here.
Est-ce que je peux commencer, Monsieur le
On
Président?
le voit pas.
Can I begin, Mr. Chair? Oh, we don't see him.
Yeah, we're sorting out a technical.
No problem.
All right, I think this is a little better now. I get the problem that we had, but I think we've got this resolved. So with that, go ahead, Minister. You have the floor.
Thank you very much, Mr. Chair. Colleagues, I want to begin by thanking all of the members of the committee for its study on the intersection of technology and policing, including the recent reports on facial recognition technology. And I welcome the opportunity to talk about the adoption of new tools and technologies, especially as it concerns transparency, privacy, legal, and ethical standards. Technology and policing have always been closely interconnected, but today's tech is advancing exponentially. Cette progression s'étend de l'évolution.
From the evolution of mobile and wireless to supercomputing, advanced analytics, biometrics, surveillance, forensics, and beyond. It is imperative that law enforcement bodies keep up with the pace of change.
Cela est essentiel pour
It's crucial that we do so to pursue those who would seek to exploit new technologies for malicious intent.
et nécessaire
This is not only necessary in order to increase efficiency, but also to closely examine how law enforcement selects and implements these technologies in order to ensure the privacy, rights, and freedoms of all Canadians.
canadienne. Nous devons trouver un.
We must get the balance right.
Today, colleagues, I am pleased to provide a brief overview of the tools used by the RCMP. The RCMP uses investigative technology and cutting-edge scientific tools in the areas of forensic science, fingerprinting, biometric and DNA data, and surveillance, among other areas. Forensic science and identification services, for example, is an integral part of National Police Services, often relying on advanced science and technology. Through these services, groundbreaking technology helps to identify biological evidence collected from crime scenes, examines firearms, seized materials, and suspect counterfeit currency or ID, screen for a broad range of drugs and poisons, and help to provide expert scientific testimony in courts. With respect to investigative technology, specifically, the latest technology available to the RCMP helps to link crimes together, secure records and documents at a crime scene, identify suspects and victims writ large, and helps to keep Canadians and our communities safe. The RCMP's CAIT program, or Covert Access and Intercept Team, uses approved technology to collect data that cannot be collected using traditional wiretapping technology or other less intrusive investigative techniques. This is only used under judicial authorization for the most serious offenses. Further, their Special Eye program is primarily responsible for the lawful electronic surveillance mandate of the RCMP. This has been the unit responsible for all interception of private communications, which can be obtained pursuant to authority under Part 6 of the Criminal Code. It involves technical installations and deployments of electronic surveillance equipment in support of policing investigations. And it involves monitoring and analysis of data and communications which have been lawfully intercepted. Toutefois, chers collègues,
But, colleagues, through all these examples, I must be clear that transparency and accountability, privacy, and respecting fundamental rights and the law are paramount. The Privacy Commissioner has echoed that sentiment. The government is committed to making sure that it is foundational to all activities, including training and operational processes.
en particulier, l'un des
In particular, one of the key outcomes of the Commissioner's investigation and report on the use of facial recognition was the need for a centralized process for the adoption of new tools and technologies.
de l'année passée,
In March of last year, the RCMP created the National Technologies Onboarding Program.
National Technologies Onboarding Program, or NTOP, is to centralize, standardize, and bring greater transparency to processes that govern how the RCMP identifies, evaluates, tracks, and approves the use of new technologies and investigative tools. It will be the first point of contact for any unit interested in using a new operational technology. It will also ensure that a thorough evaluation of the technology is completed, making sure the technology meets all privacy, legal, and ethical standards. The NTOP has begun accepting new technologies for assessment and will continue to increase capacity as it moves towards becoming fully operational. And I want to highlight that the RCMP is fully engaged with the Privacy Commissioner's Office to ensure that privacy impacts are assessed for all new uses of facial recognition being considered. Legal considerations are equally taken into account for the use of technology at all stages, including through the Criminal Code, which sets out provisions for judicial authorization and requires that we report annually to Parliament on the use of electronic surveillance. Given the RCMP's mandate and the necessity to safeguard the ability to effectively use on-device investigative tools, we are not always able to discuss all of the technical or operational details of these tools. And where that is the case, it is for operational integrity and security only. I understand, Mr. Chair, that I'm out of time, and I will be happy to take any questions from the members of the committee. Thank you very much.
Indeed you are, but I gave you a few seconds to finish there, so thank you, Minister. And we'll go to, is it Mr. Bazan for up to 6 minutes.
Thank you, Mr. Chair, and I want to thank Minister Mendicino for joining us today. Minister, when did you first become aware that the RCMP was using on-device investigation tools like Pegasus?
Well, first, I want to be clear with the members of the committee that the Pegasus technology is not used by the RCMP. So that's the first thing I would
So
clarify.
what technology are you using?
Well, secondly, as I said towards the end of my remarks, Mr. Bazan, that some of the investigative techniques are kept confidential to preserve operational integrity, to ensure that we can bring those to justice that are necessary, but always consistent with the Charter and with privacy rights.
Have you issued guidelines that would better provide direction to the RCMP, CSIS, and other federal agencies on how they use ODIT?
Mr. Bazan, that's a good question. There are stringent requirements in the Criminal Code that require accountability, including what facts the RCMP will be relying on prior to judicial authorization of this sort of technique. There are other safeguards that ensure that only designated agents put those applications to the court. There is the annual report, which we file with Parliament. And of course, I invite any suggestions from this committee during your study.
Thank you. Does CBSA or CSIS or other federal agencies that fall under your jurisdiction and authority use this technology aside from the RCMP?
Well, again, just to clarify, not Pegasus, but we do use this technique.
Okay, and how long has this technique been employed by public safety through its various agencies?
To the best that I have been informed, the use of the technique has commenced in or about 2017, but I would defer to the RCMP officials who are on the line if they wish to provide any additional details.
Well, they're in person, and then we'll get that from them later on in the committee hearing. I know that from my time when I was in National Defense that the Minister of National Defense maintains the power to provide ministerial directive and authority in the event that warrants are not possible because of time of day or weekends and middle of the night. Do you have that same authority and power as Public Safety Minister to provide a ministerial directive to the RCMP to conduct surveillance on Canadians?
Well, I want to thank you for the question. It allows me again to reiterate the importance of operational independence. Elected officials do not conduct criminal investigations, nor are they responsible for dispatching.
Sir, in charge of the direction of the agency, do you have the power to give ministerial authority when there is not the capability or the opportunity to save for a national security threat that's imminent to provide surveillance without a judicial warrant?
Mr. Bazan, as you will know, it is the RCMP who apply for those powers, and they are authorized by the court after a rigorous application on the strength of a designated agent who submits an affidavit.
Minister, was this on-device investigative tools used while the Emergencies Act was invoked?
It is my knowledge that it was not. And again, for further operational details, I would invite you to ask and put those questions to law enforcement.
We'll raise that later. As you know, National Defense was on training exercises on a King Air aircraft that was circling downtown Ottawa during those protests. Were RCMP or CSIS officers on those planes when they're surveilling those people that were on the ground for these so-called training exercises?
Mr. Bazan, I would invite you to put any operational questions directly to law enforcement.
Okay. Have you been briefed on the RCMP's use of the remote activation of microphones and cameras on our mobile devices?
I've had discussions with the RCMP and my officials. I've also had the chance to canvass the annual report, the most recent annual report on the use of electronic surveillance, which most recently was tabled for 2020. There's another report that is forthcoming for 2021. It is one of several mechanisms that we use to be open and transparent with the public about the use of this particular investigative technique.
So as we know, Pegasus, although you're saying we don't use it here in Canada, has been deployed by state actors against politicians in other countries, as well as journalists and human rights activists. We know that the U.S. has banned the use of Pegasus in the United States through the White House and actions by Congress. How can you assure us that the software, the spyware that the RCMP and other government agencies are using is not available to malign state actors here in Canada?
Again, Mr. Bazan, I want to thank you for the question. And the way that I can assure you is that question was put to our officials. The answer that I was given from them was that the branches within this portfolio do not use that technology. And I would also add in conclusion that there are rigorous protections which are put into place prior to the authorization of this particular technique, including applications which must go to a superior court judge on the strength of a designated agent who puts forward a thorough recitation of the facts on which the authorization is being sought.
Thank you, Minister, and thank you, Mr. Bazan. And now we'll go to Ms. Hefner for up to 6 minutes.
Thank you, Chair, and through you, I'd like to thank the Minister for being here with us this afternoon. Minister, in my former life as a journalist, I covered some terrorism trials, and I could be wrong, but I understand that in your former life as a prosecutor, you were involved in some terrorism cases. And based on the information provided to this committee by the RCMP, it looks like terrorism was one of the few crimes that the RCMP would use this technology to address. So I'm wondering if you can talk from your experience about why police might need to use this technology in the right circumstances with the right protocols and checks and balances in place.
Thank you for the questions, Ms. Hefner. It's not often that I get to compare notes on prior professions and the kind of alignment in which you just posed it, you being a former journalist, me being a former federal prosecutor. But yes, I am familiar with the rigorous steps that have to be followed in order to deploy this kind of electronic surveillance technique. It is not an easy thing to obtain. There are numerous steps that have to be followed, as I have pointed out in my prior answers to Mr. Bazan. First and foremost, there needs to be an application that is submitted to a superior court judge. That judge then has to take a look at the facts in very meticulous detail that will offer some evidence or information of a very specific offense which is being breached. And I would point out that, as I think is implied in your question, you can apply for this type of investigative tool or indeed wiretaps generally for any old criminal offense. There are a limited number of very serious offenses which are listed under Part 6 of the Criminal Code to which this technique would be eligible. After that, the judge has to engage in a balancing exercise where they determine, among other things, is the interception, is the technique necessary? Is it pressing and urgent enough such that it requires the technique to be afforded to the state for the purposes of acquiring information, which could then be potentially used as evidence in a subsequent criminal proceeding? Again, there is a lot of attention to detail. It is not uncommon for the courts to put questions back to designated agents before approving these judicial authorizations, precisely because we place as a paramount value the protection of people's privacy, individual privacy rights, and other protections under the Charter. So there is a lot of built-in protection into the criminal code precisely to strike the balance of ensuring that the state has the tools that it is necessary to protect the security and safety of all Canadians, while at the same time upholding people's charter rights.
And I think you mentioned that a judge would not approve these warrants if there was another way for police to collect this information. It's only a last resort.
That's correct. It's typically referred to as investigative necessity, and what the state has to demonstrate, what law enforcement has to demonstrate, is that there have been efforts at exhausting other techniques prior to coming to the court with a request for a judicial authorization under Part 6, including some of the techniques which are the subject of the study before this committee. So it really is seen not as a first resort, not as a tool of convenience, but rather as a tool of investigative necessity to demonstrate restraint, because it is important that we protect people's privacy.
There seems to be a lot of concern about mass surveillance. How do we know whether or not this occurred, and how can we ensure that mass surveillance, which is not allowed, I think, as you mentioned?
Well, I think that's a very important question, because certainly my hope is that through your study and through the contributions of all of the members of this committee, that we can enhance openness and transparency about how law enforcement deploy these techniques. And I would say that the central challenge right now for all state actors who are in the business of protecting Canadians is that they are confronted increasingly with complex encryption, which is intended to subvert law enforcement, which is intended to subvert detection. And the risks and the consequences that flow from encryption, highly sophisticated encryption technology, are that people can get away with crime. They can undermine the health and safety of all Canadians. So again, some of the techniques which are being deployed are intended to really frustrate the efforts of sophisticated criminal organizations and other bad actors, whether they be state or non-state, for the purposes of protecting Canadians. And so that's really, I think, going to be advanced by the work that you are doing, that you are studying, shining a light on these techniques, as well as the annual reports that are filed under the use of electronic surveillance. And again, I invite the committee to look at that report and to make suggestions on how we can continue to improve it if necessary. The ongoing work that law enforcement does with NSICOP, with NSIRA, all of these branches together cumulatively contribute to transparency and openness about how we are using these techniques, again, quite sparingly and as a last resort to protect the health and safety of Canadians.
Thank you. I think that's my time, Chair.
Yep, that's about right. So thank you. And now 6 minutes for Monsieur Villemeux.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. Minister, thank you for joining us today. What we're talking about is trust here. Here's what I'm wondering. What should we think about the recent revelations which were presented by the press, by Politico? What is the impact of those revelations on people's trust toward the department, toward the RCMP? You said that the RCMP is fully engaged in working with the Privacy Commissioner, but then this morning we heard that that's not so much the case. So what would be the cumulative effects of this on the population? Answer. Thank you for the question. I fully agree with you. I agree that trust is one of the keys to openness and transparency. I thank you and the committee for starting this study, which gives us the opportunity to study the technologies and tools and techniques used by police services, including the RCMP. As I already said, honorable colleague, there are many challenges on the ground now. There are geopolitical context challenges. There are criminal organizations who are using encryption in order to frustrate policing efforts. This study is thus a very important opportunity to increase transparency about how these techniques are used by the RCMP. And this will contribute to trust. Thank you very much. And yes, it is a fact that technology is advancing very quickly, and we need to be able to follow it. Yes, absolutely. Now, continuing, in your opening remarks, you said that the RCMP is assessing to determine whether tools are too intrusive. But this self-assessment of transparency might not be relevant because here the RCMP is assessing the RCMP. So I have some doubts about the trustworthiness of that process. Answer. Well, listen, that's a good question. When an application is made for wiretap, an application under the criminal code, there is a test. There are criteria and which must be met in order to prove to a superior court judge, to prove very thoroughly that criteria have been met. One of the obligations that the RCMP has, that policing has, is to demonstrate to a judge that they have exhausted all other possible options in advancing the investigation and that this is the only remaining tool. That is one level of protection which exists. Another comment, there are other mechanisms, for example, the annual report to Parliament. In the report, there is data, there are statistics showing when these applications were approved by superior courts. I welcome all members of this committee to offer other suggestions in order to strengthen transparency mechanisms. Why? Because that will even further enhance trust. We must keep trust in the system across the board in order to move forward with the use of these tools while fully respecting the Charter. Question, could there be a third party participating in the assessment process in order to have a bit of distance so that the RCMP isn't assessing the RCMP? Answer, well, yes, and there are already third parties, for example, the Privacy Commissioner. There is also NCIRA. There are also intelligence officers and security officers. There are many agencies which have the authorities and power to study this information, which is confidential, which is protected by the National Security Act and by other rights and privileges. With that branch, with that agency, we can further enhance and strengthen trust. There are indeed third parties which are already assisting us in these efforts. Thank you. Now, when we're talking about judges who approve these warrant applications, does the RCMP have the technical ability to assess all these applications? Because the applications are very complex. That's a great question. The answer is yes, they do have the ability to do so. The judges look at the legal criteria. Judges understand how we can strike the right balance between the needs of the state to protect citizens and all other rights, balancing charter rights and other rights. So judges have the necessary experience and skills to find the right balance. And that's why I trust the process. We have institutions which exist to protect the rights of each and every Canadian. Okay, fine. And here's my final question. I don't have much time left. So there are third parties observing. There is some accountability. But we can still conclude that the RCMP is spying on Canadians. Well, that is the RCMP's job. Yes. Public servants can answer technical and operational questions. They can explain how the techniques are applied on the ground in the context of investigations. But that's not to say that there's no space for improvement, which is exactly why I support and encourage this committee's work. I hope the committee will offer suggestions and recommendations to strengthen the application of these tools by police services. Thank you very much, and that's our goal too. Thank you.
Mr. Green for up to 6 minutes.
Thank you very much. In your opening remarks, I noted that you stated that you wanted to highlight that the RCMP is fully engaged with the Privacy Commissioner's Office to ensure that privacy impacts are assessed for all new uses of facial recognition being considered. That's not what we're here for today. What we're here for today, and perhaps you misspoke in your opening remarks, are on-device interception tools. We heard in the first segment of this morning that the Privacy Commissioner was not, in fact, informed on the subject matter of this meeting. Would you care to comment on the clear and obvious contradiction that you've presented in your opening statement with the testimony as provided by the Privacy Commissioner in regards to what it is we're here for today, which is the on-device interception tools?
Well, first, I want to thank you for the question, Mr. Green, and I want to acknowledge that it is unfortunate that the Privacy Commissioner has reported that he learned about the use of this particular investigative technique in the media. That is something that I have discussed with the RCMP, and I'm pleased to report to you and other members of the committee that they are now actively engaged with the Privacy Commissioner to ensure that the use of this technique, which again is used quite sparingly and only after great rigor with the approval of a Superior Court judge, is done in a manner that is consistent with the Charter.
You may have heard in the opening statements, I'm sure either yourself or your staff would have briefed you on the testimony that the Privacy Commissioner suggested as a recommendation that privacy impact assessments be a legal requirement to his office. Would you support and agree with that?
Mr. Green, I invite and support the work of this committee to offer any recommendations which it thinks will augment transparency. I would say to you, as I have said in prior answers, that there are already a number of mechanisms that assure transparency, but I think given the sensitivity of this technology, given how sparingly it is intended to be used, and again, only with the approval of a Superior Court judge on the strength of an affidavit that is put forward by a designated agent, we should always be open to having a conversation on how we can raise the bar.
Well, we're talking about it now, so I'm going to put the question to you directly. Would you support it as the minister responsible to have it included as a legal requirement, given that we're going to be contemplating a new and revised Privacy Act?
Mr. Green, I'm happy to say to you that I will be pleased to consider all of the committee's recommendations. I think it's important that we look with great scrutiny and with great merit on the suggestions that you will provide. I also want to make sure, Mr. Green, that as we take your recommendations, that we are weaving them into the overall landscape and architecture that is designed to ensure that there's transparency within CIRA.
We noted that the Treasury Board has within its policies a open by default mandate, one that would have departments proactively engaging with the Privacy Commissioner on issues of this. And yet, you know, when you look at the Health Canada mobility study that we had to have, when you look at Clearview, when you look at what we're talking about, what's before us here today, what you'll note is a habit of constantly playing catch up with what these departments are doing, because there doesn't seem to be a culture of transparency and openness by default by this government, and because it doesn't seem that these departments are willing to, in a proactive way, engage with the Privacy Commissioner. This is now the third situation, which I think could have been avoided at committee, quite frankly, if these agencies had gone on the record and pursued with full engagement and full cooperation privacy impact assessments. Would you not agree?
I think what you'll hear from RCMP officials who are there, and what I will transmit to you personally, Mr. Green, is that we always have to be prepared to up our game on transparency. There is the annual report on the use of electronic surveillance. I think that we should look at that as one of a series of tools so that we can shine a light on how we use these investigative techniques to protect Canadians. So I look forward to the suggestions that you may have and other members may have, Mr. Green, because I think in order to build trust and confidence,
I
we need to be
appreciate
transparent.
that. I'd like to know with specificity what laws and policies are in place to ensure that the tools and new technologies used by the RCMP meet privacy standards under your purview as the minister responsible.
Well, first and foremost, there are the provisions under the Criminal Code, which again contain great rigor and require great transparency and full, frank, and fair candor to the court. Secondly, there's the Privacy Act. And thirdly, I would point out,
do you not agree that those agencies also have a duty of candor to the House of Commons and that committee?
Without question. Mr.
Okay, I
Green,
just
I'm
want
not
to
here
reference
contest
with
that.
you, now that we have you here before us, that in our previous studies, in fact, we had members of the RCMP refusing to even name what was already publicly available, the person who is responsible for procuring Clearview technology. We have a culture that has been reflected in the courts as a culture of being cavalier, which came through in a judicial decision as commenting on both CSIS and the RCMP. So what are you doing as the minister responsible to ensure that that duty of candor presents us with full, frank, and completely transparent accounting for within this committee and the House of Commons?
In short, holding all branches within my portfolio accountable for those values which you just stated, making sure that the mechanisms are designed and are delivering the transparency that is required to build trust and confidence. And it is an ongoing exercise that constantly requires reflection, especially as we
Let me ask
use
you
new
this.
technology.
Let me ask you this last question. We talked about the Privacy Act. We talked about having privacy rights embedded in the preamble. We now have determined that preamble is actually not legally binding. Would you support putting privacy rights within the actual legal framework of the upcoming Privacy Act?
Mr. Green's used all of his time without.
I'll
leaving
give him time to
answer.
reflect on that and
Maybe
then
he
reflect
can
back
answer.
on it in my next round.
Minister,
Thank
if
you.
you can give us a quick yes or no to that, if you'd like to, I'll let you. But otherwise, we're going to go.
You can
next to
go.
Mr. Williams.
The short answer, Mr. Chair, is there are charter and privacy protections already built in, but I invite future recommendations as this committee may submit.
And with that, I'll go to Mr. Williams.
Thank you, Mr. Chair, and Minister, thank you for being with us today. This morning, we had Canada's Privacy Commissioner in the room, and you spoke about maintaining trust in our public institutions. Do you believe in maintaining trust in our public institutions? Absolutely. Okay. You stated this in your opening statements that this technology that you know of has been implemented since 2017. Is that correct?
That's what I have been advised.
Minister, is it acceptable to you that it's been 5 years since that the RCMP have not submitted a privacy impact assessment, and they're just completing one now? That the privacy commissioner thought that it would be provided at the end of August, but is it acceptable? It's been 5 years since they've had that completed.
Well, as I have said previously, I think it is unfortunate the privacy commissioner was just recently engaged, but I would also want to clarify to you and to the members of the committee that privacy protections are afforded and complied with in the context of the use of this technology when they apply for judicial authorizations. That's one of the important protections.
Well, Minister, my question was, do you find it acceptable that it's been 5 years? And this again, based on the fact that the commissioner this morning stated that he only learned of this in June. So is 5 years, I mean, we think June's probably too long. Is 5 years too long?
I want to make it abundantly clear to you that when these techniques are used, including ODIPs, that there has to be a balancing.
Minister, yes or no is
privacy rights.
Is absolutely acceptable. Yes or no?
I've already said that there is privacy protection built into each and every instance in when these techniques are used.
Well, sir, if you're not going to answer my question, I don't know why we're asking them to, but it's very simple. But I would assume if we have a privacy commissioner asking for very basic instances from our institutions, and you've clearly stated that we want to have trust in our institutions, would it not be acceptable that we ensure as much as we can in the government that we have the very basics concluded by those institutions?
Of course, and that's why I've said that
Thank you, sir.
the RCMP are engaged with the RCMP. With the privacy commissioner.
Thank you very much, sir. You know, this committee has been starting, and you mentioned in your opening remarks, facial recognition technology, data mobility. Technology is evolving. It's continually evolving, and this is just the latest instance. As you mentioned, 2017 was when this technology came into effect. So we assume there's a lot more of this technology into effect. To your knowledge, do you know of any other departments or under your purview that we should be looking and pushing for privacy impact assessments at this point?
Look, I would not want to preempt the independence of your committee and who you wish to study. I would invite, though, the conversation that we're having right now on how we can ensure that we are protecting privacy. There are protections that already exist, but there are mechanisms that I think that we can continue to modernize as we use new technology to subvert the efforts of criminal organized actors and other bad actors who would seek to undermine the health and safety of Canadians.
Minister, would you help that Canada's privacy laws be updated quickly? This is something that's been asked not just on this testimony today, but in past testimony. Is that something you think we should be trying to push through a little quicker?
I think we should always be looking at ways to ensure that Canadians' privacy is being protected. And again, I encourage the study that you are undertaking right now.
Minister, when we talk about procurement and procurement of such technology, and obviously someone makes those decisions, is your office aware of those decisions when they're made?
Well, there are a number of different procurements which are undertaken by independent operational decisions, which again, for good reason, lie within the purview of the RCMP. You don't want elected officials conducting investigations. That having been said, where there are requests for certain types of technology or additional resources, those are usually appropriated for under budget requests or other requests. And when those are submitted, we obviously evaluate them on the merits.
Thank you. Minister, are you aware of CSIS or a CSE or any other institution using this technology as you've mentioned today?
Well, I can speak certainly for my portfolio. And as I said, the RCMP has said that this is a technique that is used.
Okay. Are you aware of anyone else using this at this point?
Certainly, when techniques like this are used by the government, they are done in a manner that is consistent with the Charter, with privacy laws, and with all of the other mechanisms of transparency that attach to it.
Thank you, Mr. Chair.
With that, next we go to Monsieur Villemeux. Oh, no, I'm sorry. No, we do not. We go next to Ms. Valdez for 5 minutes.
Thank you, Chair, and thank you, Minister, for joining us today. So, Minister, Part 6 of the Criminal Code sets out the authority for the lawful electronic surveillance mandate of the RCMP. As with any sort of search and seizure, the Criminal Code does not provide the authority for mass surveillance, but grants law enforcement these tools only when absolutely necessary to maintain safety and security. So, Minister, can you advise this committee on that threshold needed for the interception of private communications per the Criminal Code?
It's a very high one, as you've already mentioned, Ms. Valdez. It is not an easy test to meet. There are only specific individuals who are authorized under the law who can bring forward an application for judicial authorization to conduct a wiretap or to utilize some of the investigative techniques, which is the subject of this study. It requires that the offense for which there's an expectation that information or evidence might be procured through the technique falls within a very limited number of serious offenses under the Criminal Code. And as we already mentioned, Ms. Valdez, the state has to go to some lengths to demonstrate that this technique, this form of surveillance or search and seizure is not a first resort, not a tool of convenience, but rather one that is only being requested after other efforts have been exhausted. So there are many protections which are built into the Criminal Code and the law generally that are there to achieve the balance between allowing the state to protect individuals while at the same time protecting the individual privacy of all Canadians.
And you highlighted in your opening remarks the importance of the transparency, the privacy, and accountability. And we as Canadians, we need this from our intelligence agencies. So how can we ensure that Canadians, that we respect their right to privacy and their rights set out in the Charter Rights or Freedoms, and how are those being upheld?
Well, I think the short answer is by continuing to demand openness and transparency and accountability. And that is why I'm pleased to appear before you and the other members of this committee. I invite the study that you are undertaking right now. I think it is important that we explain to Canadians why it is that law enforcement has to resort to this technology. And in turn, it's because criminals are getting better and bad actors are getting better at finding ways to avoid detection by law enforcement, whether it's through encryption or through other sophisticated techniques. They don't want to be caught. They want to get away with it. And we know that the consequences can be devastating, particularly as we start to live out more of our lives online. So these are not technologies which are being deployed, again, as a matter of convenience or lightly or frivolously. These are technologies which are being deployed by the state to protect the security and the safety and the health of Canadians. And as we deploy those techniques and those technologies, I think it's important that we shine a light as much as we possibly can without compromising operational integrity. And there is a balance to be struck there, but I think, again, to circle back to the original premise of your question, we can build confidence among Canadians if we are open with them.
Thank you. And in March 2021, our government created the National Technologies Onboarding Program to bring more transparency on the RCMP and how they gather, identify, and track new and emerging technologies. Can you give the committee some oversight on how this program works and how the RCMP maintains that right to privacy while conducting their investigations?
In plain terms, it's meant to centralize these processes. And by centralizing them, we can ensure that there's greater compliance with professional standards, with the law. Keep members of the RCMP who've been designated to apply for the use of these techniques very much up to speed on what is required by the court. Making sure that they're kept abreast of any developments in the law, because on occasion, the courts will clarify on how the law should be interpreted depending on the techniques that are being used, the technology that is being used, and how they are interpreting on how we strike that balance appropriately. So centralizing through the NTOP does allow for, I think, a higher level of confidence that we are adhering to, that the members of the RCMP are adhering to the rigors of the law with highly trained individuals who are adhering to high professional standards.
Thank you. And I think, Chair, that might be up for my time, right?
Well, you've got time for another question if you'd like, but you've got about 35 seconds.
Let me try to squeeze this in. So at the end of the day, Canadians want to know that their privacy, their families, and their rights are protected. So, Minister, how can we continue to assure that this is going to happen for Canadians?
By making sure that we have laws that protect their privacy, by making sure that we adhere to the mechanisms of transparency, by cooperating with NCIRA, NSICOP, with the Privacy Commissioner, and by continuing to engage with all parliamentarians, including this committee, so that we can have an open and frank discussion about how we protect Canadians with new technologies while respecting their rights under the Charter.
Thank you.
All right, and that will do it. And now for Monsieur Villemur, pour 2 minutes.
2.5 minutes to Mr. Villemur. Thank you, Mr. Chair. Minister, could the committee please receive all of the reports that you mentioned earlier, because it would spare us several hours of research? That would be very kind of you. Yes, of course. Thank you. Thanks very much. Now, you spoke about openness, transparency, accountability. Those are all positive things. We all agree. But what is being done to increase public trust when it comes to committing to transparency in national safety? We say that we aim for transparency but can't always give the details for national security reasons. Now, that's understandable. In your opening remarks, you said that efforts are being made. There are activities ongoing to be transparent. And we have to take you at your word on that. Since we have to take you at your word on that, is that going to lead to trust? Well, if we want there to be trust, then we need to be open, honest, and transparent. That's why your committee's work is so important. That's why it's so crucial that the RCMP work alongside the Privacy Commissioner. That is also why we need to continue to work with NCIRA and NSICOP. We need to be transparent. Sorry, I'm going to interrupt you because I only have 2.5 minutes this time. My colleagues mentioned facial recognition and geolocation of data. We're getting the impression that the RCMP is more avoidant than protective of privacy. What do you think of that? Answer. I think that the RCMP understands and shares our point of view about the importance of transparency and the importance of working alongside all institutions which exist to protect Canadians' charter rights. With a lot of effort and teamwork, the RCMP will continue to work with all parliamentarians and even with this committee to work toward transparency, which will enhance trust. Thank you. Now, what about Pegasus? Is it going to be forbidden in Canada? Yes? Thank you.
Thank you very much. In some disclosure that we had for this in preparation for this committee, we noted that there were 32 instances of this technology deployed dating back to the year 2017. In your briefing notes, was it ever disclosed to you that there was instances that were before the date of 2017?
Mr. Green, what I've been advised is that the earliest year in which this technique was used was 2017.
In the testimony of the Privacy Commissioner, when we were talking and referencing the use of Stingray technology, which sets up phantom cell towers to intercept cell phone information, it was noted that there were instances that the use had happened without a warrant. Are you aware of any instances when this might have been used, and I think it was extringent circumstances or something to that effect? Are you aware of any instances where that would have happened?
Yeah, I think the precise test would be whether or not they're exigent or emergency circumstances, but it is my knowledge that these have all been subject to prior judicial authorization. I would invite you to put the question directly to the RCMP as well.
And I'd asked this question, and respectfully, I felt like you kind of danced around it. One of the ways in which I think that this committee would avoid some of the work much of the work in which we've already done, is if we had a system in place that allowed for privacy impact assessments to happen as a legal requirement through the Privacy Commissioner. I'm going to ask you once again, is that something you would support given the work of this committee and the testimony that you've already given on the importance of privacy as a fundamental right?
Mr. Green, I guess what I'm getting at in my answer is I look forward to receiving that recommendation. I think
that's the same answer. I'm going to ask this next question in a direct way. When the privacy impact assessment is provided to the Privacy Commissioner, would you be willing to turn that over to this committee, given the foundation of the duty of candor and the power of this committee to send for documents and evidence?
Yeah, I mean, I think I want to be as transparent as I can be about those privacy impacts. I also want to make sure that we're respecting the process that is being undertaken by the Privacy Commissioner in conjunction with the RCMP. So the bottom line for me is I think the more transparent we can be, the better.
Thank you. And with that, we will go to Mr. Couric for 5 minutes, followed by Mr. Baines for 5 minutes, and that should conclude this panel. So go ahead, Mr. Couric.
Thank you very much, and thank you, Minister, for coming here today. You avoided answering the question before, so I'll maybe direct it to you in a little bit of a different way. Are you aware of any other instances of agencies or departments under your purview that have utilized this technology, yes or no?
Again, I would say to you that...
So other than the RCMP, Minister, are you aware of any... I'm not even asking you to identify those departments. Are you aware of any other entities under your purview that have used this technology other than the RCMP?
I was coming to the answer. I was just in the process of saying that these techniques, if and when they are used, are always done in a manner that is consistent with the law and the charter.
So we'll take that as a yes, although some equivocating on how you came about it. Minister, as has been the case, certainly I've seen a number of times before this committee, that the government's response seems to be, we need to build trust, so just trust us. With, in many cases, including the contradictory testimony that you've given here today with what the Privacy Commissioner spoke about this morning, and seeing how the OPQ signed off on by, I believe, your parliamentary secretary at the time, Ms. Damoff, and the letter that was provided to this committee, there's a difference. There's a discrepancy that exists. So there are provisions within both the criminal code and other legislative frameworks that allow for national security to be used to circumvent Section 6 and the normal judicial processes required for surveillance operations. Minister, yes or no, are you aware of that ever having been used while you've been Minister of Public Safety? Yes or no?
I just want to be very clear that when these techniques are used, they're done in a manner that is compliant with the law. And I've set out on a number of occasions on how...
So, Minister, my question, I think my question was quite direct. There are national security exemptions that can be used to circumvent the typical processes where there's that judicial process that you've expounded on quite fulsomely within Section 6 of the Criminal Code. So there are national security exemptions where these surveillance techniques can be used without fulfilling the full process outlined in Section 6 of the Criminal Code. To your knowledge, are you aware of that ever having taken place while you've been Minister of Public Safety? Yes or no?
I would just, again, point out that when this technique is used, it's done in a manner that is compliant with the law and the charter. And for any additional details, I would invite you to put those questions directly to the officials who are there to provide those answers.
So with respect, Minister, you are the elected official, cabinet minister, that provides that oversight that Canadians expect. And the fact that there's being less than direct answers, I think, is very, very telling of that culture of secrecy that seems to be involving. Certainly, I hear often from constituents that are frustrated with the actions of this government when it comes to its unwillingness to be forthcoming with what I think are very, very simple questions. Minister, when we see specifically with some of what the Privacy Commissioner spoke of this morning, that it's only been after the media reported on this ODIT technologies being used that the RCMP, that now the Privacy Commissioner is engaged with the RCMP. Minister, does that concern you that this confirms a trend, which we've seen from your government, where only after public scrutiny and, in many cases, parliamentary and media criticism, that's when action is taken to, in your words, quote, build the trust of Canadians, unquote?
As I've previously expressed, I think it's unfortunate the Privacy Commissioner found out through the media, and that's why I'm inviting the work that is being done today. I think we, as I've said before, should always look at ways in which we can raise the bar on transparency, particularly as we're using new technologies to protect Canadians.
So there's a lot that's unfortunate, and certainly I do look forward to tomorrow morning when the previous Privacy Commissioner, who has, I would note for the record, Mr. Chair, has had very, very public disagreements with the RCMP, among other instances. So, Minister, I hope you can appreciate that Canadians are not comfortable with the simple comments that this government seems to say of we're building trust, so just trust us. So I hope we can certainly get to some answers in this regard.
Well, I would just say to you that there are many mechanisms of transparency to ensure that there is openness, including NSIRA, NSI-COP, the very rigorous tests under the Criminal Code. That's how we'll continue to build transparency in addition to the good work of this committee.
All right, thank you. And for our final members round, it goes to Mr. Baines. You have 5 minutes. Go ahead.
Thank you, Mr. Chair, and thank you to the Minister for joining us today and being very forthcoming and telling us about the various transparencies that are available. My first question, I would like to ask you about, we've heard from experts that facial recognition technologies inherently further racial biases, misidentifying racialized individuals at a much higher rate. So if the RCMP is making use of such technologies, how are they accounting for these discrepancies and addressing these systemic inequalities?
Thank you very much, Mr. Baines, for the question. And as part of my mandate, I'm working very closely with the RCMP and indeed all branches within public safety to address systemic racism and other institutional barriers, which for far too long have led to disproportionate outcomes, particularly involving racialized Canadians and Indigenous peoples. I would invite the members of this committee to take a look at the most recent and updated mandate letters, which I have issued to all branches within my portfolio, including the RCMP, who are here before you, because we have to tackle this work together. And I want to commend the Commissioner, all of the members of the executive team for understanding and appreciating that it is a top priority of our government to do just that. And we obviously have a long way to go. I don't want to give this short shrift. I know that the committee's looking at a very specific issue, but I completely take your point that the institutional barriers, the systemic racism have been a real problem and have plagued all of our institutions, including law enforcement, for far too long, and we're looking to right the ship.
Thank you for that. And so you mentioned the National Technologies Onboarding Program. Can you provide this committee with an understanding of how this program will provide greater oversight on the use of technologies and investigative tools used by the RCMP?
Thank you for the question, Mr. Baines. I think in some ways, I've discussed this previously with Ms. Valdez's question, but in essence, what the RCMP have done is they have created this branch, this particular office, if you will, to centralize our efforts in the use of this technology. And by doing so, we can be sure that there is very clear and high expectations set with regards to professional standards, that there is training that is provided to those members who have been designated to apply for the use of this technology. And as part of that training, to be sure that they are kept abreast of any developments in jurisprudence in the law, so that where there needs to be improvement, where there needs to be course correction, where there needs to be greater sensitivity to ensure that we're protecting privacy, that we are adhering to those values, because as I think we've heard throughout today's conversation, one of the running themes is that we all want to build trust and confidence, but in order to do that, there needs to be transparency and openness and accountability. And I think the creation of this office is designed to do just that.
So just to follow up to that, what involvement, if any, do you have with the RCMP decision-making process as it relates to the decision to use ODITs in a particular case?
None. These are operational techniques, and we don't want elected members of the government or any elected politician for that matter directing or trying to steer investigations, which by extension would include investigative techniques or judicial authorizations. There are safeguards, including constitutional principles, which have been established by the Supreme Court to safeguard operational independence. That's something I believe. I hope that's something that all of the members of this committee believe. You don't want me or any other elected member directing the use of this technique.
Thank you. Any more time, Mr. Chair?
You've got almost a minute. If you'd like to ask another question, go ahead.
Okay. So, Minister, in your view, what advances in encryption technology convinced the RCMP that traditional means to monitor the communications of possible criminals were no longer sufficient?
The emerge of counter-surveillance technology like encryption, which is being used by criminal actors and bad actors who are trying to undermine public safety and national security. And it is through the detection of those counter-surveillance techniques and technologies that the law enforcement and the RCMP have had to develop and utilize other techniques to make sure that we can bring those who are trying to do harm to Canadians to justice. It's very difficult, it's complex work, but there are protections that are built into place, including the tests under the law and other transparency mechanisms so that we can accomplish that balance.
All right. With that, I will, and just before I suspend the meeting to transition to the next panel, I would like to thank the Minister for his time and for his willingness to appear at committee. And with that, meeting suspended.
Thank you, Chair.
So welcome back. We I'm going to convene the second panel now of today's meeting, and with us now for the second panel from the RCMP, Mark Flynn, Assistant Commissioner, Federal Policing, National Security and Protective Policing. Brian Larkin, Deputy Commissioner, Specialized Policing Service, and Dave Kobe, Sergeant, Technical Case Management Program, Technical Investigation Services. So we will begin our second panel with opening statements. If you have one from the RCMP, go ahead for up to 5 minutes.
Bonjour à tous. Good afternoon, Mr. Chair and honorable members of the committee. The RCMP is grateful for the opportunity to speak with you today about this important matter. We hope that our comments will inform your study into the RCMP's use of on-device investigative tools, commonly known as audits. Encryption is essential in our modern world. It protects financial and other sensitive information and helps ensure Canadians' online activities remain safe and private. Unfortunately, encryption and the devices that help protect Canadians' privacy also help criminals conduct illegal activities and avoid police detection. Although police are sometimes able to collect data stored on those devices, encryption often renders the data unintelligible. Before I go into detail on what audits is, I would like to be clear. The RCMP has never procured, never used the Pegasus software or any other NSO product. Audits are used extremely rare and in limited cases. Their use is always targeted. It's always time limited, and it's never to conduct unwarranted and/or mass surveillance. These tools are not used in secret. Audits require judicial authorization prior to deployment, and the evidence collected, including how it was collected, is subject to disclosure and court scrutiny. Given the RCMP's mandate, we are not able in this setting to discuss specific operational requirements, and the RCMP is not able to disclose sensitive details related to the tools and techniques used in the course of its investigations. Any public disclosure beyond the technical documentation that we provided to the committee that describes the general capabilities of an audit has the potential to adversely impact our investigations. Our use of audits is in full compliance with Canadian legislation, including the Charter of Rights and Freedoms, the Criminal Code of Canada, and established jurisprudence. Audit technology may be used to assist in high-priority investigations relating to national security, serious and organized crime, and other criminal code offenses that impact the safety and security of all Canadians, and only will be deployed after judicial authorization has been obtained. Now, for what an audit is a computer program that's installed covertly on the cell phone and/or computer of a suspect. Audits assist investigations by maintaining law enforcement's ability to covertly collect private communications and other data that can no longer be acquired using traditional wiretaps and/or less intrusive investigative techniques. The amount and type of data collected is determined on a case-by-case basis in accordance with strict terms and conditions imposed by the judge who authorized the use of the audit. The RCMP's cautious and measured approach is evidenced by the fact that since 2017, audits have only been used in support of 32 investigations in which a combined total of 49 devices were targeted. Again, I emphasize that in the past 5.5 years, we've targeted 49 devices for audit deployment. The RCMP carefully considers the advantages and disadvantages, including the impact on privacy and third parties before seeking judicial authority to use audits in support of all criminal investigations. That assessment is conducted in close collaboration with investigators, technical specialists, federal and provincial Crown prosecutors, and is overseen by our technical case management program within RCMP headquarters. Again, we stress audits are only used for serious criminal offenses. It's only approved by a judge who explicitly authorizes the use of audit on a specific suspect's device. Judges receive and continue to receive supporting material explaining what the audit is and its capabilities. Although we are not able today to disclose the name of organizations with whom we work with in a public setting, we would like to again confirm that the RCMP has never procured or used Pegasus or any other NSO product. Sharing details publicly exposes sensitive information that could negatively impact the RCMP and our public safety partners' ability to effectively use audits in the future. Criminal elements also use this sensitive information in order to render the tools ineffective. Further, in addition to negatively impacting the RCMP's investigations, the exposure may jeopardize investigations of foreign partners and our relations with those countries. In April of this year, we provided a detailed briefing on the RCMP's use of audits to Canada's National Security and Intelligence Agency, Review Agency. On August 23rd, representatives of the Office of the Privacy of Commissioner Canada will also receive a similar briefing. I would like to bring to the committee's attention that on July 4th, 2022, when the National Security and Intelligence Committee of Parliamentarians, NSICOP, notified the Minister of Public Safety of its decision to conduct a review of the lawful interception of communications by security and intelligence organizations, which we will fully participate in. The objectives of the review include examining the current state of lawful access, concerns raised by civil society, as well as privacy experts, technological challenges, as well as the gaps. On the basis of its review findings, NSICOP may make recommendations pertaining to various aspects of lawful intercept activities and frameworks.
I'm so sorry, Mr. Larkin, but I've let you go significantly over the time allotted for opening statements, and your testimony is important, but we're going to have to get to questions from members. But even before we do that, I will say on behalf of a committee that voted for some very specific information from the RCMP, it was quite disappointing, in fact troubling, to receive in Commissioner Lucky's letter what amounts to just a point-blank refusal of information. We heard in the earlier committee of the, as Canada's Grand Inquisitor, the committee of Parliament has unfettered power to request documents. We can have a discussion about the appropriateness, and you touched on that in your remarks, and I look forward to the discussions that we'll have from the parties about that. But just a blanket refusal to a committee is troubling, and we'll get to that, I'm sure, with questions from committees. So with that, I will go to the first round, which will begin with Mr. Bazan.
Well, thank you, Mr. Chair, and I want to thank our witnesses for being here, and I thank the RCMP for their work. And you know, I do believe, as us on the conservative side here, that we want to make sure you guys have the tools to do the job, that you can keep Canadians safe and deal with issues of national security and public safety at all times. But there's also the need to protect the rights of Canadians, the privacy of Canadians, and their charter rights, and there is concerns around the unintended consequences of deploying ODIT, or OTIS as you're calling it, and the potential that those that aren't necessarily being targeted are also being spied on using the technology that you have. There's also been confusion here, because when we actually had the order paper question that was tabled by the RCMP via the Parliamentary Secretary to the Minister of Public Safety in the House back in June, it talked about 10 or 12 cases that were where OTIS was used. Then in the rather disappointing letter that came from Commissioner Lucky, talks about 32 investigations. And now you're saying it's 49 individuals that were actually spied on. So, the number continues to move, Mr. Larkin, and that is, I think, something that we're all very concerned about, is where does the truth actually lie? And that's why I think we need to have better clarity on the information you have. Now, you talk about that, and we already know that you're not using Pegasus, but you do have a technology. Is it made in Canada, or what's the source, the country of origin of this technology that you're using in your investigations?
Well, thank you so much, Mr. Bison. I just would like to clarify that we actually have deployed 32 applications targeting 49 devices, not 49 individuals. So just a point of clarification. But I will defer to Assistant Commissioner Mark Flynn to discuss the technology and the procurement of such.
So within the RCMP's Technical Investigative Services, there is a process under which they procure all technology. There's an approval process where it's a Director General level approval for both the procurement of the tools and techniques, as well as approving which particular tools and techniques can be utilized by the RCMP in our covert electronic surveillance.
Disclose whether it's Canadian technology or if it's or the country of origin where you get the technology. If it's not Pegasus, then what? Where does it come from?
So from my perspective in federal policing, I'm not aware of where all the technology comes from that's utilized here, but I can say I have a long-standing history in this, and back in the days from 2002 to 2015, it was all Canadian technology that we were utilizing. But
so this predates what we're talking here, 2017 for Otis. So you're saying that we've been using this technology since 2012?
I can add some clarification to that, and actually it goes back prior to 2012. And I can add some clarification to that.
Okay, and so we've used this technology, hopefully respecting, I guess Part 6 of the Criminal Code, that the charter rights have been protected. How often have you used it under national security provisions where you don't have to get warrant? Going back to 2012 or before, like we're talking Otis, and we're also talking, I believe it was through your Special Investigation Unit I, right?
So from my involvement, again, back for many years, as well as my current position in national security, we have never utilized this tool without prior judicial authorization. However, having said that, if a situation were to arise that required it, there are provisions that allow us and certain designated individuals to utilize this type of tool for the interception of communications in emergency situations, but I am not aware of any situation where that has been done. And the mere practicality of deploying this type of tool and technique would take it beyond the time period under which such an authorization would be valid.
So when it is a national security issue, or it's an area where it's, somebody like, we had, Canadian Navy former Lieutenant Jeffrey Delisle, and that was back to 2012. Now you're saying that this would have been probably used in that situation, knowing that he was a member of the Canadian Armed Forces, knowing that there may be people of interest within the RCMP. Do you still have to go through the process of getting, warrant to protect the issue, their charter rights in the Criminal Code, Section 6, or can you, on staff, surveil them or use spyware without their knowledge and without the consent of a justice?
I can say that unequivocally that in that case and in any other similar case, we have utilized the prior judicial authorization for doing so, and not obtaining such judicial authorization would be a violation of Part 6 of the Criminal Code, because that is the privacy invasion provisions under the code, and we would not do that. We are a professional organization who operates under the law.
So as a professional organization that's been using this type of spyware since 2012 or sooner, why did it take until it became public information that you never consulted with the Office of the Privacy Commissioner?
So I can speak to, again, a long-standing history in the Special I program. And as we follow through the evolution of the use of this technology, as encryption started to be used by targets that we had judicial authorization to intercept, and we were unable to hear the audio, hear the phone calls, or see the messages that they were sending, that is when we developed the tool and technique to make it possible to intercept those communications. But it's important to note the privacy invasion isn't coming from the tool utilized. The privacy invasion is coming from capturing that audio, or capturing that text message, or capturing that communication that is occurring between two individuals. Okay. And we have evolved in the use of the tools as individuals evolve in the way they communicate.
Okay, thank you. You're over time a fair bit there, but I wanted to let that answer go without interrupting. But we must now go to Ms. Khalid for up to 6 minutes.
Thank you, Chair, and through you, thank you to our witnesses for appearing today. I'll start by asking, just to kind of put all of this into context, how many investigations have been conducted by the RCMP in general over the past 5 years?
Chair, through you, are you asking the total number of investigations?
Yes, the total number of investigations.
As I sit here right now, I don't know that number, but it would be a large number.
Okay, and out of that large number, how many of those investigations used audits? Now, I heard 32 or 35. I just wanted to clarify.
Yes, so since 2017, only 32 investigations have used audits.
And how many of those investigations were conducted without a warrant?
Mr. Chair, through you, every one of those 32 investigations had a judicial authorization to use audits.
And what kind of criminal activities were in question at the time that audits was used within these specific cases?
Mr. Chair, I believe that was in the package that was provided. It breaks down into several different types. The most investigations related to terrorism or serious drug trafficking investigations, or there was also 5 murder investigations, and there were also some breach of trust investigations, one of those being the investigation of police officers' activities. But in a total, all combined, they were 32, and they were all 32 investigations that had at least one offense that was under the Section 183, which the Minister mentioned in the previous meeting, which are all serious offenses.
Thank you. And so the RCMP is subject to the Privacy Act. So what practices do you in general within your department use to ensure that your device investigation tools comply with the Privacy Act?
So I can say, as of most recently, when we've initiated our National Technology Onboarding Program, really that program, really the genesis of it was the OPC's report of Clearview AI. And as a result of that report, one of the recommendations that the OPC made and which the RCMP agreed to implement was to have a more centralized process to ensure all privacy-related considerations were followed, including assessing early in the process whether a PIA is required, and if yes, ensuring that PIA is written, as well as other internal RCMP requirements related to data security, whether a warrant is required, if a warrant is required, the terms and conditions and language that needs to properly describe technologies are included in that warrant, and things like that.
And we heard from the OPC earlier today that it took a while for the RCMP to get to them. Why is that?
I'm not sure in specific terms on the audit in particular, but I can tell you following the OPC investigation and since NTOP has been established, we're working to really redouble our efforts to, as early as possible, identify these technologies, and if personal information is implicated, beginning the process of engaging the OPC as soon as possible.
Thank you. And just in terms of the scope of audits within the investigations, is there a big capacity for people that are not the subject or the target of an investigation to be captured within audits, for example? Or are there any mitigation factors that the RCMP uses to make sure that it's very, very limited in scope?
So one of the attachments you would have received was the sample judicial authorization that we shared with INSERA for the purpose of their demo. And the short answer to your question is the authorization that gets prepared in relation to an audit deployment includes several terms and conditions imposed by the judge, which require us to, if information unrelated to the investigation or not pertinent to the offenses being investigated, if that information is captured, yes, that has to be set aside and dealt with in a protected manner, as well as other information, for example, information related to solicitor-client privilege and things like that. So many of the terms and conditions included in a regular Part 6 or wiretap warrant are included and read into our audit warrants. As we've used these new tools over the years, we've tried to really take a cautious approach to implementing them to make sure those those terms and conditions are followed.
And I'll ask also. This question came up earlier with the minister as well, with respect to racial discrimination, as we've learned through the facial recognition technology, that that race is a huge component as to how surveillance happens, and the RCMP is working on it. Does not have a good track record. I'm wondering if you have anything to say to that, and what measures you are taking as you use technologies like this within its limited scope to ensure that that there's no racial profiling.
I can tell you, in relation to audits in particular, our unit, our Technical Investigative Services Unit, we are a technical support unit that provides assistance to investigations. So our involvement is at the level of assessing the technologies that are implicated in the investigation as opposed to particular targets. And so really that's not something our unit is in a position to really have an impact on, because we're really looking at the devices and the technical challenges to achieve the collection or the interception that the investigators are trying to.
All right. Maintenant, Monsieur Villemure.
Merci beaucoup.
And now, Mr. Villemure. Thank you, Mr. Chair. And thank you for joining us today. Now, without compromising national safety and security, but I want the people in my riding of Trois-Rivières to understand something. A few things. So I have some questions for you. First, can the RCMP set up a software on someone's phone without their knowledge?
La GRC est-elle capable de capter?
Can the RCMP capture or listen to a conversation on a cell phone?
With judicial authorization, yes.
Oui, évidemment.
Yes, of course. Can the RCMP see what's on a screen or what can be seen through the camera?
Depending on the device and our capabilities at the time, the answer can be yes.
Okay. De consulter.
Can the RCMP look at contacts, text messages, calendar, the content on the phone?
With the same caveat, yes.
Parfait, merci beaucoup.
Okay, thanks very much. Now, the Privacy Commissioner this morning and the Minister said that you were fully engaged. Those are the words they used. But even so, before using that software for the first time, did you, yes or no, consult the Privacy Commissioner?
No.
Okay, merci beaucoup.
Okay, thanks very much.
Un autre ordre.
Now, another line of questioning. Commissioner Lucky's letter that we received the other day, it disappointed me too. Our question was very clear. Well, we got a very, very clear answer. We asked whether parliamentarians had been listened to, and the answer we received was the RCMP cannot offer that information. Do you have anything to add to that?
I would just add that when we're speaking about any individual in particular, to ask a question about parliamentarians specifically, it's a challenging question because it's actually putting the authority of the individuals asking in a position to speak to something that they care about. We take the privacy of all Canadians, regardless of the position they hold, to be very important, which is why we put all the protections in place. However, I would add that there are certain sectors, which include parliamentarians, journalists, religious institutions, educational institutions, where we have additional safeguards within our policies and procedures to ensure that a higher level of authority is required if a request is being made or an operational requirement is in place due to the criminal behavior of the individuals involved that fall within those sectors. It requires a higher level of approval. For national security matters, that is my position as the Assistant Commissioner in charge of national security.
Merci beaucoup.
Thank you very much. Now, political parties. Have political parties ever been under surveillance, monitored?
Again, that goes back to speaking about particular targets of investigations. And I can say that parties themselves, I have great confidence without having reviewed. So I put a strong caveat on here. Without having reviewed all judicial authorizations. The RCMP does not target political parties. Okay.
Merci beaucoup.
Thank you very much. I'm very happy to hear that. Now, question. Given how quickly technology is evolving, do you feel that we should have some sort of moratorium or ban on use so that people can understand what is at stake here? Because we have to admit that it's all rather complex. So do you think that a moratorium would be a good idea in order to have more people understanding what's going on?
I do not believe a moratorium is necessary. And again, going back to the point I raised earlier that led to the evolution of the use of this technology, we are talking about the most invasive techniques that we can have when we're speaking about interception of communication, whether that be an analog telephone conversation or whether that be an encrypted conversation. The privacy, not the difficulty or the level of complexity in the technology utilized, is what needs to be protected.
Okay.
The RCMP has protected that technology. The laws of Canada have protected that right to privacy, and it does not speak to the level of sophistication required. And I think those protections are valid today as they were back in the 1960s.
Merci beaucoup. Monsieur Larkin.
Thank you very much. Mr. Larkin, earlier I heard you say that foreign partners... Now, I understand that you don't want to compromise any external or international investigations, but would you be able to tell us whether Canadians could be under surveillance or monitored by foreign organizations?
Well, thank you very much, Mr. Villemure, and I'm going to actually turn it over to Assistant Commissioner Mark Flynn, who looks after national security and protective services. But I'd like to reemphasize on your previous point that the RCMP recognizes that there are gaps in current legislation, and we think that the work of this committee is very important to enhancing and actually mitigating those risks, mitigating those gaps, and we're very open to working around that process, around also in transparency. I think it's very important for us to recognize that as evolution of technology is outpacing our ability to keep up, necessarily there is a required need for enhanced legislation mitigating those risks to allow us to ensure accessibility and accountability, but also ensuring the privacy of Canadians. But I'll turn over your specific question, Mr. Villemure, to Mr. Flynn.
Merci.
If possible, could you just repeat the key point of the question? I just want to make sure.
J'ai entendu M. Larkin
Mr. Larkin talked earlier about foreign partners, and I wonder whether some foreign partners, which are likely countries, are any of them possibly monitoring or surveillancing Canadians right now?
Thank you for the question. The key distinction I needed to get there was foreign partners.
Yeah.
So as you'll know, there are agreements internationally with certain partners that there will not be surveillance amongst particularly the Five Eyes on our citizens. However, I would say from my position in national security that you must be concerned, you should be aware that foreign states, I would say that are not partners, would absolutely be utilizing these types of tools and techniques. And I see around this room many electronic devices. All of you are using them as much as anyone in society today. And you must be concerned and must be aware that you are being targeted. And I have very little doubt about that.
Merci beaucoup.
Thank you very much.
Answer.
Thank you for that that candid answer. We went over time on that round, but that was important information. And now to Mr. Green.
Thank you. Who is the ranking officer amongst the three of you?
Mr. Green, that would be myself as the Deputy Commissioner of Specialized Policing, and I've recently transitioned from a municipal police force as a Chief of Police.
Well aware in Waterloo region.
To
You've
the
done a lot of
Deputy
work there.
Commissioner of Specialized Policing, and one of my mandates has been to ensure.
I just need the confirmation on it. I do appreciate it. You'll also appreciate that in our timed rounds we have to be expedient. So you've probably heard me then request from the minister responsible that the RCMP provide this committee with the privacy impact assessment that is being prepared right now for the privacy commissioner. So being the ranking officer, would you commit to doing that, to handing that over to this committee at the appropriate time when it's prepared?
Again, Mr. Green, we're very much open to advancing transparency within the RCMP. We look forward to our meeting on August 23rd, and it's something that we would certainly consider sharing with this committee as we move forward to build transparency and to enhance trust amongst Canadians. So,
do you have the authority? So I can, just so that we're clear, because we do have the ability to send for documents unfettered, and I'd rather not have to do a motion that would request that document. If I could just get your commitment here on the record here today on the Hansard, that we can do that. And if there's things within the privacy impact assessment, I'll have you note that this committee has the ability to go in camera, like NSICOP, like others, I did hear some referencing, Mr. Chair, that there was some discomfort around having discussions around the partners and the places of origin for this. And so given that we've gotten your commitment that you will provide the privacy impact assessment to this committee at the appropriate time when it's prepared, would you be willing to go in camera with this committee to perhaps expand on the use of this technology so that we have access to the same information the government has?
So, Mr. Chair, just to clarify, one of the caveats, Mr. Green, would be yes on the privacy impact assessment, but also recognizing that there may be sensitive information which would be best shared in camera.
Right.
And so, again, we welcome any opportunity, as we're doing with the Office of Privacy Commission, NSI COP, to go in camera to share further details. We're certainly willing to do that, and we welcome that opportunity.
Okay. You know, as I'm sure you're well aware of in Peel's principles, the ability of the police to perform their duties is dependent on the public approval of police actions. And I think you've been present to the previous interventions that we're having some trust issues. We had members of your service refuse to provide basic information to this committee, which in my opinion is in contradiction to your duty of candor. And so I'm hoping that at the appropriate time, you know, and again, we have 4 meetings, but I think that there's probably going to be an opportunity to revisit some of this stuff once the privacy impact assessment is completed, and we would get a chance to perhaps invite you back in camera to expand on our learning as a committee, because we've heard time and time again, Mr. Chair, from the minister responsible that he is keenly looking forward to our recommendations, and despite some of the protestations of the government members of this committee, is actually excited that we're having this discussion. So I guess, you know, if there's a question that I have looming from today, it is processes of oversight. And I reference in a sample letter, have you been privy to the sample letter that was provided by the RCMP? It was on a warrant. I referenced it in the morning, and it talked about interceptions on devices, investigative tools. Section D, it's on page 6, that when oral communications have been intercepted using an audit, the monitor who subsequently reviews the communication must cease reviewing the communication as soon as the monitor determines that no person in paragraph 3 is a party to the communication. Would you be willing to go on the record right now and say that's a standard practice within these warrants, that parameter?
Yes.
Okay, I'm seeing the nod. It's on the record, yes. Who would be responsible for providing oversight that actually happens?
So these warrants are, as you see, you have a sample. So the warrants are issued by the judge. It would be within the technical investigative services would have a role to play in terms of ensuring technically the warrant is implemented in keeping with the terms and conditions. And then in terms of the information collected, like you say, actually reviewing, that would be within the purview of the investigative team and a small number of people who've been, you mentioned the monitors and analysts assigned to do the first review. They would be responsible to make sure that condition is followed. And then,
so would there be, just so that my understanding, again, as we're trying to collect our own evidentiary process and the ability to send for papers and so on and so forth, on these 32 warrants, would there then be an audit or a report generated that would substantiate that that type of legal protection against the encroachment on the privacy of private citizens unrelated to the investigation would be protected?
I'm not aware of a report being produced for each case, but the ultimate accountability would come when the practices, the evidence collection practices, are challenged in court when these accused.
But I mean, that's not proactive. Surely that's not the best case scenario in terms of internal policy to protect the privacy of Canadian citizens. Have you contemplated in this emergent technology proactive ways in which you can have your own internal checks and balances? Because quite frankly, what we continue to hear from the government and from law enforcement agencies is take our word for it. I'm now asking you, given that you're responsible for reviewing the legality and the charter protections, and quite frankly, as I'm going to understand, the only party who has access to whether or not you're actually doing what is presented in the warrants, is there any reporting mechanisms that happen within your departments that would reflect the ongoing adherence to the warrants as they're being produced?
So I can tell you, I'm not sure if you're interested in hearing them, we've implemented several proactive steps to make sure the warrants or audits are implemented effectively earlier in the process. we haven't specifically contemplated that report.
Okay, thank you.
And with that, we will now go to the second round. First up is Mr. Kurek. Go ahead.
Thank you very much, Mr. Chair, and thank you to the members of the RCMP that are here, and thank you as well for your the work you do to protect Canadians. There's a few questions that I'm hoping to get as direct of an answer as possible to. One, we've heard a lot, and there's a little bit of discrepancy around the number of authorizations and the number of individuals and the number of devices, and so that's not specifically what the number that I'm looking for here. But is there, in terms of the number of requests that have been made for judicial authorizations, but requests that were denied, do you have that number available?
You mean judicial authorizations or requests to use audits internally?
Well, both if you could. The requests internally to use the ODITs and any judicial authorizations that were denied. So I guess two different numbers.
So the number of Part 6 authorizations denied is tracked in the annual federal wiretap surveillance report. So those numbers would be there. Do you want the other number as well?
Please.
So anecdotally, in terms of the number of investigators who request audits versus the number of investigations on which audits are deployed, it's anecdotally, I would say 1 in 10 investigations that seek audits, are interested in using audits, would actually make it through our process and have audits deployed, because our process is quite rigorous and because it's a very challenging practice to implement these tools. Very few of investigators who request them actually end up being able to use them.
Okay. So when it comes to the use of ODIDs, and it's obviously very, very complicated, and we've talked a lot about the technological aspects of that, but one of the challenges that has been raised that exists when using this sort of technology is solicitor-client privilege, attorney-client privilege. Are there any examples where ODIDs have been used where it's come in confrontation with attorney-client privilege and the use of this surveillance technology? And are there protocols in place to ensure that the rights of Canadians are protected in that regard?
So the short answer is yes, there are protocols in place. The sample warrant you received, which is this, again, the sample Part 6 authorization, includes specific terms and conditions related to solicitor-client privileges, and whether it be audit-collected information or information via a traditional telephone call, those terms and conditions must be followed.
Okay. So there's a couple of other questions that I'd like to ask, specifically related to the both testimony and I've now served on this committee over the course of 2 parliaments, and there's been some very public disagreements between the leadership of the RCMP and the Office of the Privacy Commissioner. And as was stated today, some of the frustration that there seems to be a hesitancy for the RCMP to disclose documentation to Parliament. Are you aware of the testimony that the Privacy Commissioner offered this morning? And would you agree that it was only after this information was made public at the end of June that the RCMP engaged specifically with the Office of the Privacy Commissioner related to ODID's use in your investigations?
So I guess, again, it goes back to the evolution of the technology, because in my history in the lawful access debate for 20 years now, the use of this type of technology, the challenges from presented to the RCMP and policing in general from encryption has been a topic of discussion that involved Privacy Commissioner, criminal law policy, a DOJ, human rights law section for many, many years. However, going back to more recent time frame and the June date, I don't recall the exact order here, but I do know that Technical Operations did invite the Privacy Commissioner's office to the presentation that's occurring in August. As well, you'll have noted some public articles that have been published by people such as Sergeant Dave Colby here that is meant to bring more public visibility into what we are doing. We are pulling back the veil. We are trying to do that in a way that's professional, respects both the law around the protection of tools and techniques.
So if I could, because I'm almost out of time, one of the concerns certainly that I think has been highlighted by this committee is that it seems like only after details have been revealed, and this is not limited to this circumstance, is the RCMP upfront about some of the details related to their investigation. I would simply like to put one more thing on the record, and that's one important distinction. NSICOP is a committee of parliamentarians, not a standing committee of parliament, and I think that's an important distinction that needs to be made.
Thank you. And with that, you're out of time.
Yeah.
We'll go next to Ms. Hefner for 5 minutes.
Thank you very much, Chair, and thank you to the members of the RCMP here with us today. I just want to start by asking, why not do a privacy assessment every time the RCMP starts using some new technology? Why wouldn't that be one of the first things you do is a PIA?
So I would add again, going back to the point I raised earlier, it is a debate that we have, and sometimes it involves a discussion with the Government Advisory Group at the Privacy Commissioner's Office as well. But we do take a look at what we are doing. And as I said, whether we're intercepting an analog communication or an encrypted communication, we're looking at the privacy is in the content, not in the method of delivery. So as we moved through time, we were looking at, are we actually invading people's privacy anymore? And when it gets to a point where we believe there are concerns, and I've personally been involved in meetings where we've received advice that no PIA is required because we are not hitting the triggers. And as an organization, we are changing our position in those. And I would say that even in one particular case, we are moving ahead with a privacy impact assessment, even though all of the advice that we have is that one is not required. So we are trying to lean forward. We are moving forward. You have 3 people at this table today that believe strongly in erring on the side of reveal the details and allow people to properly assess whether or not there actually is an additional invasion of privacy or whether or not we are simply doing things using a new method but still substantially invading privacy at the same level as we previously had when authorized by judicial authority.
And on that, it looks from your background information here that you actually would need, is it 2 warrants, a transmission data recorder warrant and a general warrant to intercept computer functions and use audits? So it would be 2 warrants. Do judges, in your opinion, really look at the privacy of unrelated people, or are judges concerned about Canadians' privacy when they're assessing these warrants?
So to answer your question, it's actually more than 2 warrants. Predominantly, the omnibus order that we seek requires, in addition to Part 6, which is the interception of private communication warrants. So there's that warrant. There's a general warrant that is required for the deployment and use of the ODIT, the technology in the background. There's a transmission data recorder warrant, which is required to collect the transmission data that we would collect to operate those. And then if the ODIT is being used to collect information related to the location of the device, we also seek a tracking warrant. So all of those warrants are required or included predominantly in the authorizations we seek. Occasionally, we would seek only a general warrant if the objective was to only remotely search a device for historical information, but most of the time we're using these tools for investigations that are ongoing and seeking prospective communications, private communications. So all those warrants I listed, including a sealing order and an assistance order, are sought at the same time.
Can you, I think it was actually Mr. Flynn who talked about how some technology, similar technology, was used as far back as 2012. And I don't think we heard much detail about that technology and what was being done in 2012. So I'm wondering if I can give you a chance to expand on those comments.
If I may, I'll add one element that I believe judges absolutely do understand the privacy, and that is their primary responsibility in weighing the needs of police to utilize such techniques. So going back, as in one of the previous questions, the DeLille case was raised. And if you look at the DeLille case, you will actually see in the news coverage that the RCMP, as part of our disclosure package, did present some of the material that was collected using the ODIT, which included screenshots of some of the communications between the accused in that case and what is believed to be foreign actors that he was engaged with. So when we speak about the technology, we hear spyware, we hear malware. I'll be frank, I don't believe it is either one of those. We are using tools and techniques that are designed to enable us to meet not meet, but to perform the duties that are expected to be performed by us in gathering evidence about the criminal behavior of, and you can see from the stats provided solely for 2017 onward, that it is involving serious cases with serious criminality.
Yeah. Thank you very much. I think that's my time, Chair, or do I have more time?
No, yeah, that just we're just a little over, but we are done. And so now, Monsieur Villemur, pour 2 minutes et midi.
Merci.
2.5 minutes, Mr. Villemur. Thank you very much, Mr. Chair. In the documents, there's mention of 2016. It was a possibility to launch public debate about the use of this technology, which didn't end up happening, and maybe you can explain why. But is there an openness to using invasive technologies?
An openness to discuss the use of invasive. I think the translation may have missed a fine point there. I would say there's absolutely an interest in publicly discussing the use of invasive technologies. We're here. We're happy to have that discussion. Again, you'll see the news articles that cover it. I won't waste your time. So,
Vous êtes depuis 2010.
You have been in your position since 2017, is that right?
I've been involved in this type of technology since 2002. I moved into a different position in 2015, and now I've been in my position in National Security and Protective Policing since December a year and a half ago.
D'accord.
Okay. Now, still referring to the RCMP's desire to discuss this publicly in 2016, can one of you explain why this didn't occur?
I'm not sure any of us can actually respond to why it didn't occur in 2016. If we're very candid, Mr. Villemur, none of us were involved or actually participating in that process at the time. So,
Si jamais vous avez la réponse, vous pouvez la fournir.
Well, if ever you find the answer, you can give it to us in writing, and that would be great. But I'm just quoting from RCMP documents here. Now, we have been discussing trust and confidence. Now, this isn't a witch hunt. Our goal is to possibly help you to accomplish your tasks and fulfill your mandate in the best conditions possible. Now, would you be open to third-party assistance or third-party assessment in order to ensure that we are not just forced to take you at your word?
I would say the short answer is yes, and our involvement with senior federal and provincial prosecutors to make sure we get it right in terms of sharing enough detail with judges is an example of where we've reached out to third parties to try and get it right.
D'accord.
Fine. Thank you very much.
All right. Thank you. And for 2.5 minutes, Mr. Green.
Thank you. In the committee's latest study on facial recognition technology, the RCMP representatives told committee about a new national strategy, the National Technology Onboarding Program. And it's supposed to ensure that new technologies are assessed before they're used. Why not just bring the Privacy Commissioner in there in an official way?
So thanks very much, Mr. Green, and I think that will be one of our processes when we meet on August 23rd is to discuss how we actually modernize and evolve NTOP. That actually looks at all technology, centralized technology, so we have actually regulation, monitoring, good audit, as well as also embeds GBA Plus and legal assessments, et cetera. So that is a recommendation that we're very much open to and something we look forward to.
So given that the RCMP is currently subject to the Privacy Act, what practices are currently in place, perhaps referencing this new onboarding program, that ensure that the RCMP's use of device investigation tools complies with the Privacy Act?
If I may, can I just respond briefly to your previous
Sure.
question? So in terms of the NTOP and the OPC being involved, we would actually, and I'm not sure the status of it, but we actually did request if the OPC would have an interest in embedding somebody
When
in
would
our
that
program.
have happened?
It would have happened shortly after the report was released.
Again, this kind of speaks to the reactionary way in the culture within the RCMP, quite frankly, that I've observed after the fact. And I guess, you know, with that being said, I still have a bit of a gap in what happens when the monitoring happens that might breach that fine line, right? Of like, here's our target is now around people not under investigation. Would that process also be open to in a review basis? Because, you know, 32 occurrences that we know of going back to 2017, it feels like the privacy commissioner could have a meaningful role to play so that we don't, at this committee, have to embark on finding out after the fact in the media, quite frankly, which is a bit problematic.
I can tell you, as someone at the working level who's working every day with investigators and tech specialists to get this right, yes, we'd be happy to have more engagement from third parties like the OPC.
Thank you.
Thank you. Now we'll go to Mr. Williams for 5 minutes.
Thank you very much, Mr. Chair, and thank you again, gentlemen, for attending today. I think, you know, the biggest balance we're looking for here is the balance between national security or your investigative work. That's very important. And then ensuring we have public disclosure and protection of privacy laws as a whole. And we know that's very difficult sometimes. I think, as our colleagues have indicated, part of the reason we're here is that and it was based on parliamentary work that was just asking certain questions in Parliament, and it was a shock or surprise to parliamentarians to find out that something was being used and no one knew anything about it, including who we would trust would be the Privacy Commissioner. So hearing today that technology has been used for 10 years, and like my colleagues have stated, we had investigations on other technologies like facial recognition technology, and from that we also found that the RCMP were not totally engaged with the process. We found that there wasn't that communication. So knowing that and knowing that the one tool that the Privacy Commissioner has asked for, which is going to be implemented here in August, why, I guess just from a general standpoint so I can understand, why was Privacy Commissioner not engaged even 3 years ago when this was really being used in the judicial system, in different processes? What is the best answer about why the Privacy Commissioner, who explained to us this morning, have complete airtight systems that keep everything confidential better than we can in an open committee in the public today, but why was that not the first step taken by the RCMP?
So I can speak back even further than the last 10 years, going back more than a decade into almost 2 decades ago, in that, again, looking at what is the actual privacy invasion. We're focusing a lot on the tool and the methodology, but the privacy invasion is the listening to the conversation, seeing what people are physically doing. We've installed for years, I've gone through the full special eye training program that is to install listening devices, hardware devices, cameras, hidden discreetly in a particular location where criminal behavior is occurring. This is a new method of invading privacy, but invading privacy at the same level as that it had been previously, whether it be using those other techniques or through covert entry, where you then extract all the data off of a computer, again, adhering to the terms and conditions of the court order. So when you ask us when do we get to the point that we are actually seeing a level of privacy invasion that's different than what we have done before? That's really where the triggers come in for us. And for those of us that have lived and done this work for 2 decades, you are seeing a slow evolution. So there are times where we do need the checks and balances that come in and say, it's time to reflect. New people to come in. People like Sergeant Dave Kobe's come in and is a strong advocate of being more public about what we're doing. He writes articles for the different journals, the newspapers, et cetera, to try and bring visibility to this. That's really what the trigger is.
And I guess, and I 100% agree with that. But at the same time, we're here today, and what we talk about is the word trust. So we're trying to create and maintain 100% trust with government institutions and RCMP. So would it not have made sense to counter your argument that the Privacy Commissioner would have been the first one that would have been engaged in that process to ensure there's 100% trust and accountability?
So as I stated earlier as well, I am aware that the Privacy Commissioner's Office, previous Privacy Commissioners, Department of Justice, Criminal Law Policy, Human Law Section, have been involved in the lawful access debate that speaks to really the reason behind the use of this technology and others for 2 decades. I know all of you are well aware of the lawful access debate and its multi-generational aspects to it. So I know those conversations have occurred at some levels. What made it to the Privacy Commissioner themselves, I don't know. But I do know that we have had discussions, and I can relay to you one in particular, where we had a very fruitful conversation with the Privacy Commissioner's Office around lawful access. We felt there was a strong understanding, and later on, we received some contrary messaging. So we've been involved in this debate. We welcome the transparency. We are open to it.
And I
like
think
the work.
And what's
that's
great,
happening.
I think what part of this committee's work, or the whole work, is to have recommendations, because we're also modernizing our Privacy Act as a whole, not only to catch up to Europe and the Americans, but probably to try as Canadians to get ahead of it. So what I'm going to ask for in writing, if I can, is recommendations from your end, not just from our end. What from your end can we see to have more transparency and to modernize our Privacy Act the best we can, and including protecting the confidentiality that you need to ensure that this kind of thing doesn't happen again? And I think the biggest part that we're trying to talk about, we have trust in our government institutions. We've stated this over and over. So I think that's where we're coming from. We want to see that. What recommendations can you give us that make sure that is maximized?
Thank you.
very much.
I'm not sure if that was really a question, but even if it was, we don't have time for an answer.
No, written format if I can.
So
Through you, Mr. Chair.
I think there was more a request for a written response there, and we'll take it as requested that way, and move on now to Ms. Valdez for 5 minutes.
Thank you to the RCMP for joining us for this study. Mr. Chair, through you, I'll be directing my questions to Sergeant Kobe. Anyone else can jump in to add additional comments if needed. So Sergeant Kobe, can you give us some detail on what criteria are used by the RCMP to determine whether these on-device investigative tools are used?
I can. Thank you for the question. So in terms of the criteria used, it's probably the most helpful way for me to explain this criteria is to briefly take you through our process. So initially we have a consultation with investigators who are considering these tools. During that consultation, we explain to them, we demystify these tools and explain just how complicated they are, the fact that they aren't necessarily going to be able to deliver the evidence that they want, and we really encourage them to consider other less invasive tools if possible. So step one, we make sure they really understand what they're getting themselves into and have the resources to do it. Following that consultation, they have to submit an official request from their chain of command to our technical investigative services so that there is executive awareness and oversight of their request to make sure that it's been properly monitored. After that request, and if it's approved on our side, then we have a second consultation involving their Crown prosecutor, or if they don't have a Crown prosecutor, we insist that a Crown be assigned so that a Crown understands the risks and the potential rewards of using these tools. One thing we make clear during that consultation is that, these are new technologies and we fully expect that they will be litigated. And so we make sure that they understand the litigation risk and the types of sensitive information that we're not able to share and would seek to protect under Section 37 or Section 38 of the Canada Evidence Act. So that whole process to date is really intended to make sure they understand if there's another tool that works, you should use it, because these tools are complicated. And again, there's no guarantee they're going to work. After all those consultations, then we do an engagement memo between our unit and the requesting unit to memorialize all the conversations, to set out the need to protect the tools, and then only after that engagement memo is acknowledged by the commissioned officer overseeing that investigation would the assistance be provided. And of course, all that doesn't matter a whit unless judicial authorization has been granted through the process that we've described earlier in terms of a Crown agent, a proper authorization with all the terms and conditions we included. So I hope that answers your question.
And it does. So what kinds of information can be obtained through audit searches that can't be obtained through a simple search warrant?
Well, typically audits are being sought during the investigation. So the objective of the audit, of course, is to collect the information while the target is still using it. Conducting a search warrant on a device necessitates taking the device away from the person. So obviously there will be an end to that person's use of the device. So the information that can be collected is information that the suspect is still using or saving on that device before we've seized it or before they know that they're the target of a police investigation.
Thank you. Now, former Prime Minister Stephen Harper has been deeply involved with the Israeli startup company CoreSight AI, whose technology helps to identify facial recognition features in situations when they are difficult to identify. Are you aware of the RCMP using any of this software technology?
I personally am not aware of that particular tool.
Thank you. My understanding is that the members of opposition have indicated that the RCMP conducted mass surveillance of the population and actually members of parliament. Do you have any comments on that?
I would go back to the earlier comments that these tools are never used to conduct mass surveillance. Again, the judicial authorization is only granted by a judge if they're necessary and the judge is satisfied that a particular offense involving a particular person and particular devices, and that the way that those devices are going to be intercepted have been set out. So it is very targeted. It is never mass surveillance.
Thank you. Can you describe what are the challenges that you face in conducting search warrants and how this technology can better assist the RCMP in collecting key evidence?
So I'll start with the second part of that question first. I think this technology can assist collecting valuable evidence because, like every one of us in the room, criminal suspects carry devices, and I suspect every one of us in this room uses a device in a way that is more complex for law enforcement. The apps we use and the way we use our devices, none of those are conducive to the old-fashioned wiretap activities that enabled us to, simply send our order to a telco and then have them send us the communications. All of the devices, the fact that users have complete choice over what device they buy, over what apps they use, and how they use that apps is why audits are essential, because they help us manage all that complexity.
All right, thank you.
Thank you.
Now, so that takes us to the first two complete rounds per the motion adopted by committee. I am going to deviate from that just because time is becoming a factor. So for the third round, we'll go to 4 minutes each for Mr. Bazan and Mr. Baines, 2 minutes each for Mr. Villemure and Mr. Green, and then 4 minutes each for Mr. Couric and Ms. Khalid. So that'll get us just about jammed into ending on time, maybe a minute or two over. So with that, go ahead, Mr. Bazan, for 4 minutes.
Thank you. And it's been an interesting discussion. Now, when you go for a warrant, does the RCMP need to notify the service carrier that somebody that has one of their devices, Rogers, TELUS, Bell, that their system is being hacked with RCMP spyware? Is there any duty to disclose?
I wouldn't characterize our activities the way you have, but I would say the service providers are not involved when we use audits.
Okay, so when, again, when you're monitoring conversations, using their microphone, hacking in to look at their chats and their emails, what about the other third parties that are innocent bystanders? Friends, relatives, spouses, as an example. How do you protect their privacy?
And it's a great question. It's in protecting innocent third persons' privacy and non-pertinent communications has been an issue ever since wiretapping began. And if you look at the sample order that we provided, there are terms and conditions in there set aside the ODIT for a moment, there are terms and conditions for regular wiretapping that require, again, we'll go back to privileged communications. Privileged communication between a solicitor and their client have to be protected and treated in a very special way. The same applies to ODIT collections, and some of the terms and conditions in that sample order, which is representative of the orders that we seek, includes the fact that non-pertinent information related to third parties and others has to be set aside and protected and only dealt with as guided by the court. And another specific example that is also included in that order is the requirement that that hot mic feature that is described in the technical document, that can only be activated if there are reasons, grounds to believe one of the principal known persons, we call them, the people.
So in the case where you got solicitor-client privilege, you're monitoring an individual or meeting with their lawyer, and they say, okay, well, by the way, not only are we, laundering money, but we also got a drug shipment coming in through the port. You wouldn't act upon that information?
Well, no, if a person is involved in a communication with their solicitor, the terms and conditions are clear. They have to be sealed, and we can't look at those without further order of the court.
Okay. Okay. And I just want to quickly, Mr. Flynn, you're talking about, you've been around a long time on this file. Can you talk to the memorandum of understanding that the RCMP has with CSIS, and with CSE in particular, as a communication security establishment, that it does a lot of the, has a lot of the spyware and been using it, deploying it internationally on non-Canadians. What type of relationship does RCMP have with CSE?
So the RCMP, speaking broadly, as the question was, from a national security perspective, we work in partnership with all the national security agencies, which obviously include CSIS, CSE, CBSA. I could go on a long list of the national security partners. Specific with respect to our relationship with CSE, CSE does have a Mandate C provision for providing us technical assistance through technical operations, where TechOps manages that relationship with CSE. But I can say that in that relationship, it does not expand the authorities of the RCMP.
Okay, thank you. And Mr. Chair, just because of the way the information that we requested that we never got, I'd like to move the following motion. That pursuant to the motion adopted by the committee on July 26, 2022, the committee reaffirm its request for all documents outlined in its original motion, that any documents received from the RCMP that includes warrants, list of warrants, the scope of warrants, and the affidavit submitted in support of the warrant applications be considered by the committee in camera only, and the following parameters outlined below. That all documents issued pursuant to this motion be provided to the Office of the Law Clerk and the Parliamentary Council within 15 days of the adoption of this order. That all relevant documents be vetted for matters of personal privacy information, ongoing police operations, and national security by the Law Clerk and Parliamentary Council within 7 days of the receipt of the documents, and that all documents be circulated to committee members at the earliest opportunity once vetted. I'll just speak to that motion, Mr. Chair, because I want to just assure committee members and the RCMP that we don't want to undermine any investigations you have right now that are looking at criminality or national security. What we do want to see is just the broad scopes of what those warrants look like and the documents that are associated with them, and that we would ensure through the vetting process that we've used in the past, a number of parliamentary committees at the Law Clerk and Parliamentary Council would ensure that documents are redacted and that the information that's withheld from us as committee members fall in line with protecting those investigations and national security and the privacy of those individuals who are subjects of interest. I've forwarded this into the clerk and I've asked that they have it circulated, so all committee members should have the motion before them now. I just received it myself, so it's in both official languages.
Okay. It is in order, and so before we do anything else or return with the limited time we have left to rounds of questions, we go to debate. I have Ms. Khalid.
Thanks, Chair. I would respectfully submit to members. Obviously, I haven't had the chance to review, but we do have the RCMP here for another 11 minutes. I suggest that perhaps we go to our witnesses and then, having reviewed this motion, deal with it as a first order of business in tomorrow's meeting.
Okay, I guess that's a suggestion. I can canvass the room. Is there interest in? Sorry?
No, Mr. Chair, I'd just say this, that I think we should, based upon the lack of information that was provided by the RCMP, I appreciate what they've given us to give us some background information, but doesn't talk to the broader scope of the motion that we brought forward in the respect of
Okay, I was
parliamentary
merely
process.
just.
But I'll just say this, that we should deal with this motion, because tomorrow we have a full slate, and I'd like to
We
get
do
through the
indeed.
witnesses
Okay,
tomorrow
so
rather than spend all day debating this motion.
So I had Fergus, Mr. Fergus has his hand up as well, and did I see anybody else in the room? Nope. Okay, so Mr. Fergus is the only other one I see right now. Go ahead, Mr. Fergus.
Je voulais dire la même chose, Monsieur.
I wanted to say the same thing, Mr. Chair. I feel that it's getting late, and I'm wondering whether we could have the chance to read the motion. Then we could continue questioning witnesses who are here today, and then we could consider this tomorrow. It could be the first order of business tomorrow morning. So Ms. Khaled and I have the same idea, the same suggestion.
All right. Procedurally, I'm not. Okay, I'm going to just spend one moment, get a quick word from the clerk. Okay, we really are running out of time to do both. Have additional questions of our witnesses and still, and allow time to if members wanted time to consider this motion. But I guess unless there's an actual motion to adjourn or suspend the debate, there really isn't any way for me to deal with this. I see that. Ms. Khalid's got her hand up again, and so does Mr. Fergus. Go ahead, Ms. Khalid.
Thank you, Chair. And Chair, I again just want to reiterate, because based on the what we've heard today from the RCMP, from the OPC, from the Minister, I feel that there may be other documents that we might want to add to this list. For example, we heard that there was some activity in 2012 that we may want to pursue, and that's why I was hoping that we would have some time to perhaps go back, review the testimony, and see kind of how else we can strengthen this motion, what other documents, rather than to keep on doing it again and again and again, in a piecemeal kind of way, to do it in a more substantive and a more fulsome kind of way. I am, for myself, quite interested in the 2012 reference that was made. I know that some members might be interested in other things that perhaps we could include with the text of this motion, perhaps. But I just wonder if there are members who would be willing to just give it a little bit of time to see if we can really expand this out.
Okay, thank you, Mr. Fergus.
Merci encore une fois, Monsieur le Président.
Thank you, Mr. Chair. If you would like a motion to adjourn debate, I would be happy to move said motion. I'm wondering whether we could have a friendly agreement among colleagues. As I said, I would like us to deal with this first thing tomorrow morning at 11. This would give us the time to read the document and give some thought to what Ms. Khalid has suggested. There may be ways that we could improve the motion. So could we at least, though, have a few moments or a few hours to read this in order to perhaps suggest modifications? And at that point, we will be able to have a quality debate. I think that would be the best way to proceed. But I would like to know if...
Mr. Fergus, if you are in fact moving to adjourn debate, that's dilatory and non-debatable and ought to be voted on. In terms of just doing this without a vote, I'm seeing some furrowed brows and shaking heads in the room, so I don't know that this could be done other than by way of vote. So if you have moved, Mr. Fergus, to adjourn debate, then I'm going to have to call a vote.
Est-ce que mon micro est...
Is my microphone working here? Can you hear me?
I can hear you in translation, but you're not very loud in the room.
All right. Glad you can... Oh, so you can't hear me in English?
I can hear you. Yeah, I can hear you in English now. You're okay now.
All right. Well, Mr. Chair, I mean, really, I guess I don't have the pleasure of being in the room, or actually, I have the great pleasure of not being in the room, given where I am. And is there no appetite for us to just have this debate first thing tomorrow morning?
No, but I think there may. Am I sensing from the room there is appetite to adjourn debate?
He moves to adjourn. To deal with it.
Okay. No. There is no consensus anyway to lead this to the morning. There are members that are very keen on the witnesses. We have a full slate of witnesses. I mean, I would offer the opportunity, and we went 2 hours only for tomorrow. I think that we have built into our availability some time for committee business if we extend one of the meetings tomorrow. Is that a possibility?
That works for me.
Okay. I would suggest, this is my proposal, that we, following the time allowed for witnesses tomorrow, I'll maybe make it in the first panel, just in case people are traveling after the second panel, that we have some time for committee business where we can consider both the motion that Mr. Bazan has made or any possible amendments that may expand the motion that Ms. Khalid had in mind. Is that reasonable? I'm just I'm looking for a cooperative solution here.
I think procedurally you have a motion on the floor and you need to have debate or a motion to adjourn debate.
Indeed, you're right. We have a motion on the floor, which either can be voted right now if there is no debate. I see Ms. Khalid has her hand up, and we're at about 20 minutes after 5, and I'm going to have to. I can't let this go too much over 5:30 with the House resources. So go ahead, Ms. Khalid.
Thank you, Chair. And you know what, to speak to the motion itself, I'm sure Mr. Bazan took some time to draft it. I'm sure he conferred with his colleagues that are in the room. And again, I said this earlier today as well. I will reiterate. If you'd circulated the text of the motion to myself, to any of our Liberal members, with a little bit of notice, we would have been able to review the document. We would have been able to have a substantive conversation. We have 2 minutes left in a committee meeting, and we are now being forced to vote on something that we haven't even reviewed. We haven't had the opportunity to have a conversation about this. We haven't been given the courtesy by members in this room to say, hey, look, this is what we're proposing. And, let's do this. Let's get this done. Like, we're here, we're willing, we're asking questions, we're taking interest in this very important study. We would just hope that we can be more collaborative. I absolutely agree with the chair. I feel that it was just a click of a button. You could have flipped me an email, you could have given me a text or what have you, and we would have been able to have a conversation on the side or simultaneously as the committee hearing was ongoing. And now all of a sudden, we're faced in a place where I haven't read the full text of the motion. It's on my phone here in front of me. I haven't read it. I haven't contemplated what scope. I haven't had the time to digest what I've heard from the RCMP today to see where that lack is. I would like for us to be a little bit more collaborative, Mr. Chair. This is very unfortunate that we're having to complain to you about this lack of cooperation. I understand that y'all have the votes. You're good to pass your motion in whatever way that you want. I just ask for a little bit of respect for the committee's time, for everybody's time here, just to be more cooperative, to be more collaborative, and for us to be able to get things together without being so confrontational all the time, folks. We're here to help. We're here to work together with all of you guys.
All right, thank you, Mr. Fergus.
Thank you again, Mr. Chair. And it really comes down to that. I mean, look, folks, there's an opportunity. I think we're all on the same page here. I think we all are keenly interested in this issue, and we all want to have a fulsome debate. I think there's an opportunity for us to do this. Let's be frank, we don't have a full roster of witnesses tomorrow. I think the chair's suggestion was a very, very cooperative and I thought suggestion and one which I think everybody can support. We have time tomorrow that we can do this without cutting back on witnesses. So why not? It's only a couple of hours later, folks.
All right, I have Monsieur Villemure.
Est-ce que ce serait possible de s'assurer que
Would it be possible to ensure that we have the right equipment, that everybody has the right equipment so that we can hear tomorrow? Because unfortunately, it's been a few minutes that I can't really hear what Mr. Fergus is saying, and I really like to hear what he says.
You are correct, Mr. Villemure. We have had a little bit of audio trouble from time to time with Mr. Fergus was cutting a little in and out and was hard to hear at some moments. I'm not sure what we can do about that, but other than to ensure that there's awareness. I have both. I don't know who's first. I think I'm Ms. Khalid first because I think we had. I think Greg was. We just had Greg. So go ahead, Ikra.
Thanks, Chair. And like in the interest of the plan that you had presented, which I find to be a reasonable one, I move that the debate be adjourned until tomorrow on this motion.
Sorry. The motion with the condition added there becomes debatable. So is there anybody that wishes to speak to the motion? Or Ikra, you could remove the condition and just say simply that a debate be adjourned on the motion. Okay, adjourned until tomorrow. Okay, then. Okay, there's no debate, so then we would. I guess it's okay either way. Then we go to the vote.
I believe Sorry, Chair. I believe Mr. Fergus's hand has been up.
He had. Okay, I think his camera disengaged, and then when that happens, I no longer see his hand. So go ahead, Mr. Fergus.
My apologies. I was just going back to reading the motion on my P9. J'aimerais présenter mes excuses.
I would like to offer my sincerest apologies to all of my colleagues and especially my colleague from the Bloc Québécois. The reason I do not have my headset is because this meeting was called while I was abroad. So I'm abroad. I do not have my usual computer or headset with me. I apologize for that. I sincerely apologize to all colleagues and also to interpreters.
We are. We're at this point where, well, if there's no other debate, then we can vote on Ikra's motion, which is to adjourn debate. Are there any opposed to adjourning debate? Seeing none, the motion to adjourn debate is carried, and with that, we are past our time. We will. The meeting is adjourned.
Thank you.